Good morning.
Good morning, Chair.
Ms. Ramakaka, Rugen Paka, okay, Johnny, we are in your hands.
Right. Good morning, Commissioners. Today, we will be leading the evidence of Ms. Renate Talliard. She has taken a stand and she is ready to lead evidence. May I just indicate to the Commissioners that we would like to apologize for not starting at 10 o'clock as we had intended to, because we had some logistical problems. We worked into the early hours of this morning arranging the bundle, and we also tried to make some copies in the early hours of the morning, but then we could not finish and we only finalized that this morning. We were supposed to have also done some final consultation with the witness yesterday, and that was only finalized today, and it is not due to circumstances within either the witness's control or the evidence leader's control. Thank you, Chair.
Thank you. Can the witness take the oath?
Do you swear that the evidence you're about to give will be the truth and nothing but the truth? If so, raise your right hand and say, "So help me God."
So help me God.
Right. Ms. Talliard, you have made a statement that is going to be used in the presentation of the evidence before the Commission. Is that correct?
That is correct.
And you do have before you a statement that appears on pages 1 to 36 of the bundle.
That is correct. Forgive me just in breaching the procedures, but I just also want to greet the Commissioners. Good morning, Commissioners.
Right, thank you. Will you please turn to page 36 of the bundle? Commissioners will only be using one bundle that is put before you. The second bundle that may be brought will just comprise of the book Up in Arms written by the witness. Yes, are you at page 36? Right. Do you recognize the signature that appears at the bottom of that page?
I do.
And do you confirm that the statement that appears on pages 1 to 36 is your statement, and you confirm the truthfulness of the facts that appear in that statement?
I do.
To the bundle, there is also your curriculum vitae, which appears on pages 37 and 38 of the bundle. Do you confirm that that is your curriculum vitae?
It is.
Now, shall we then go back to the first page of your statement? You are an adult female senior lecturer, the Department of Political Science at the University of Cape Town, and you are also a commissioner at the Independent Electoral Commission.
That is correct.
And you were appointed the Member of Parliament for the Democratic Party in 1999, and subsequently as a member of the Standing Committee on Public Accounts during April. May I just correct this? During January, February 2001.
That is correct as correct.
Commissioners, I'd like to request that paragraph 2 of the statement be amended to read during January, February 2001. Thank you. Now, you have been requested to provide evidence to the Commission relating to the acquisition of the SDPPs, and mainly your evidence would focus on the oversight role of SCOPA, and you have actually indicated your willingness to assist the Commission to an extent possible. Am I correct?
That is correct, with the advice that I've also received from the evidence leaders with respect to my role as a commissioner, for which I am grateful.
Right, thank you. Will you then turn to second page of the statement? Please take us through.
I'm sorry, Ms. Ramaka. Just before we proceed, I couldn't quite understand what the witness is saying now. Because she seems to be suggesting that she's going to testify about the oversight role of SCOPA. And she further says that taking into account her functions now. I don't quite understand what does that mean. Can you just ask the witness to clarify? Because we've got 5 terms of references as far as this commission is concerned. And I think the witnesses understand what those terms are. I thought he's going to touch on one of the 5, but then if at all is going to be only the oversight role of SCOPA. And she also talks about her current functions as a commissioner. I'm not quite sure, well, what does that actually mean? Can you just ask the witness to clarify that to us?
Right, thank you, Chair. Mr. Liar, do you understand the Chair's concern? Will you please address that, please?
I will happily do so. Thank you also for the opportunity. Mr. Chairman, in terms of the issues related to the Electoral Commission Act, I had concerns with respect to Section 9.2 of the Electoral Commission Act, because Section 9.2 of the Electoral Commission Act indicates that commissioners, in terms of their conduct, should not be expressing themselves on matters that are in contention between parties. And I was advised by the evidence leaders that in terms of the interpretation of statutes, and indeed Clause 2 on the interpretation of the Act, as well as Clause 4 of the Electoral Commission Act, I would still be at liberty to testify as broadly as possible. I had reservations, but the evidence leaders last night provided me with a legal opinion, which I think perhaps ought to also be read into the record of these proceedings.
Ms. Ramaka, you see my difficulty is that I thought we have called the witness to come and testify and help the commission to deal with the 5 terms of references that we have. And I thought the witness, I've seen his book, I've gone through the book, and I was much more interested in the things that she mentions in these books because they are relevant to our terms of reference. But then I would not want a situation where she says that, I am unable to talk about other things because of my current position. I really don't think that her current position really stops her from giving evidence here. I don't think that she can withhold some information from us saying that because of her current position. Her current position has got nothing to do with what we have called her to testify about. She needs to tell us as much as she knows about what happened during this procurement, and she knows our terms of reference. 1.1 up to 1.5, this is the one that we're interested in. And we thought, when I gone through her book, I thought she deals to a very great extent with 1.5. And that is why we suggested that she must be put on the list of witnesses. Can you just please help us and deal with that? Because if it's going to be an academic lecture about what should have happened and what should not have happened, I'm not quite sure if that is going to help us. We are interested in knowing exactly what she knows about what happened in this procurement, and particularly dealing with 1.5, which deals with criminality. That's what we're interested in. Are you in a position to take the matter any further, Ms. Ramaka?
Yes, thank you, Chair. May I just indicate to the commissioners that the manner in which this statement is structured is such that the witness would talk broadly about topics that are enlisted there. Executive accountability. She will address the tensions between the executive and parliament in relation to the SDPP procurement. She will talk about the contractual validity questions on and corruption issues. You know, those also touch on the issues of impropriety. And may I also indicate to the commissioners that the witness has not burdened her statement with the detail in the book, but in the presentation of her evidence, there will be cross-reference to the documents that are attached to the statement, as well as the book. I have indicated to the honorable commissioners that I think very soon the book would be placed in front of the commissioners too, so that there will be also cross-referencing there too. So it's just the scheme of things as to how the statement is structured, but as it goes on, it will be touching on specifics, and where necessary, it will also be touching on, presenting a case in point relating to the concepts that are addressed. Now, regarding the issue of the witness's position as a commissioner of the Electoral Commission, she has, I think, adequately addressed the commissioners about that, to say she had reservations, and she brought this to our attention very early during our consultation, and we then undertook or agreed that we would give her an opinion on our opinion on the interpretation of that provision. And that was done, and it was sent to the witness, and maybe the only oversight that we did was failure to then make it part of the bundle, and we will hand that up in due course. But she has expressed an understanding that, thanks to the opinion and the engagement, she now fully understands that she should be in the position to can respond to all questions that are put to her. The opinion also does address that, commissioners. Thank you.
Thanks a lot for that explanation. It's just that I wanted to make certain that she is given the opportunity of telling us as much as possible about what she knows, particularly relating to item 1.5 of our terms of reference, which deals with criminality. I didn't want it to appear as if she's going to hold back because of those concerns. And that is why I thought that, we need to address this issue quite early. But thanks a lot for the explanation. It appears as if, you have adequately dealt with that issue.
Thank you, Chair. I just hope that I have characterized the understanding of the witness well, and maybe she should be given the opportunity to just indicate as to whether I have characterized her understanding well.
Thank you very much, and thank you also to you, Mr. Chairman. I have to say that having served now in Constitutional Office for 3 years, I have a very keen awareness of what it means to prioritize the conduct of a commissioner in terms of the law. So there will be times when I will feel in this context that those duties and obligations to the Constitution may be in conflict with some of the issues that will arise. That will in no way deter me from expressing myself with candor. That has always been the way in which I've expressed myself in the public arena, but I do have a duty to the Constitution and to the obligations in the Electoral Commission Act that I do believe would override in certain cases. But I have structured a statement as candidly as possible, and I expect the evidence leaders to also lead my evidence as candidly as possible. Thank you.
Thank you. Should we proceed, Chair?
Thanks a lot. We can proceed now.
Right, thank you. Now, shall you then go back to page 2 of your statement? Please take the Commission through paragraphs 6, 7, and 8 of the statement.
Thank you so much. The facts contained in the statement are, unless the context indicates otherwise, within my personal knowledge and are, to the best of my knowledge and belief, true and correct. I am privileged to be here to share some of my experience as a parliamentarian over 13 years ago with you today. I hope and I trust that the perception that the witnesses during this cycle of the Commission's hearings are somehow here as whistleblowers or those who have to table their allegations of corruption will be addressed both by those of us who testify here about the clear policy implications of the decisions that were taken around defense expenditure in the early years of our democratic state, as well as the lessons from this experience which we can all learn to strengthen our democracy. This will be the focus of my testimony. Such an approach will not only enrich the subsequent recommendations of this Commission, but also the deliberations that our country will have about new threat analyses, as well as possible future procurements in accordance with the new Defence Review and debates on the strategic posture of the SANDF, as well as the forced design and procurement decisions that may flow from these discussions, which will undoubtedly include a discussion about the expenditure on defence as a percentage of GDP in the face of the imperatives to build an African standby force under the auspices of the AU Peace and Security Council. During these debates, the spectre of the arms deal will be there, and we will therefore all have a duty to ensure as much light as possible flows from this Commission's work if we are to have future policy debates with a semblance of rationality.
Right, thank you. Please turn to, are you in now in page 3 of the statement? Yes. You mention in paragraph 9 of your statement that if we replicate any aspect of the decision-making models that were in place at the time without critically interrogating what went wrong and learn the requisite accountability lessons, we will be doomed as a country to repeat them. And then you go on to the next paragraph to indicate that there are certain issues that you'd like to touch on in your statement. Now, the next page, page 4, section B, that deals with the section 9.2 of the Electoral Commission Act. Now, in the light of the discussion that we held earlier with the commissioners, just to clarify the issues, would you still want to go through this portion of the statement, or would you just like to address any issues that are outstanding and maybe even introduce the opinion that you received from the evidence leaders?
I would like to do so. I'm not sure whether I'm at liberty to read the legal opinion into the record at this point, or whether that could be circulated, or whether the commissioners would prefer for that to be read into the record.
I think the essence of the opinion has already been placed on record, and maybe just for the completeness of the record, what you should now go ahead to do is to hand up a copy of the opinion if you have it with you.
Definitely, I only have that in electronic form.
Commissioners, with your indulgence, we will hand up the opinion during the adjournment. Thank you. Then you may proceed, ma'am.
Not to waste the Commission's time, proceed with paragraph 15, correct? I was elected to our country's second democratic parliament in 1999. One of the parliamentary committees on which I served was the then Portfolio Committee on Public Enterprises. I also served as an alternate for my then political party, the Democratic Party, as an alternate member of the Portfolio Committee on Finance.
Now, in the following paragraphs 17 and 18 and 19, you are dealing with your engagement, especially with regard to the invitation that you received as a member of the Public Enterprise Portfolio Committee regarding the Defense Industrial Participation component of the country's SDPP. Now, in paragraph 18, you say this visit took place on the 2nd to the 7th day of July 2000. Will you take the commission through the paragraph 19 regarding this trip?
Thank you. I think that this paragraph also shows clearly that long before I became a member of SCOPA, the issues on the defence industrial participation were there. So let me just proceed. We visited the Defence Diversification Agency at Farnborough, as well as GKN Westland, BAE Systems, the Defence Export Services Organisation, and Rolls-Royce. All these entities were closely linked to the Strategic Defence Package and the BAE Saab Gripen and Hawk component of the deal, the most expensive part of the defence procurement. Prior to the departure of the Portfolio Committee, many of its members, including myself, expressed concern at the absence of a proper programme for the visit to the United Kingdom. However, it soon became clear that the purpose was to further clarify the roles of DSO and the DDA, and these entities' approach to offsets and smart offsets. And all the entities visited, including the supplier companies, spent a significant amount of time discussing the offset obligations in the SDP with the committee members. May I continue? Upon our return to South Africa, I wrote to our then chairman, Mr. Sakiwe Belot, indicating that it might be a prudent approach to hold hearings on offsets along with the Portfolio Committee on Trade and Industry, given the significant role these offset obligations appear to have played in the SDP selection criteria for the military equipment that was preferred by the Interministerial Cabinet Committee.
To this letter as RT1A in the bundle. Is there anything that you'd like to highlight in respect of that letter?
I think the letter is relatively self-explanatory. What you will notice is that there is a strong emphasis on the Denel component of the offsets.
The witness is talking about commissioners appears on pages 39 to 40 of the bundle. Right, you may then proceed, ma'am. In paragraph 21, you are now dealing with the Auditor General Special Review report and conclusion.
During 2000, the Auditor General's special review of the selection process of strategic defence packages for the acquisition of armaments at the Department of Defence concluded as follows. And I quote from the actual special review, as mentioned in paragraphs 3.1 and 3.2, material deviations from generally accepted procurement practice were discovered. The explanation provided by DoD for this material deviation does not appear to be satisfactory. Based on the review performed at prime contractor level, there were no other material findings other than those mentioned in paragraphs 3.3 to 3.9. The review focused mainly on the awarding of contracts to prime contractors. Many allegations regarding possible irregularities in contracts awarded to subcontractors exist, of which the finding in paragraph 3.6.1 is an example. That reference was to the Corvette, incidentally. The relevant pages from the Auditor General's report are attached hereto as Annexure RT2.
That annexure appears on pages 42 to 48 of the bundle. Is there any portion that you'd like to refer to in particular on that annexure?
Just to draw the Commission's attention to the paragraph that deals with the frigates in particular, and I've already quoted from the elements of the conclusion that highlighted concerns around subcontracts. I just want to emphasize that from the document.
Right then, will you then proceed to the paragraph 22 where you are making a recommendation?
This was fortunately the recommendation of the Auditor General.
Let's read that into the record.
I recommend that a forensic audit or special investigation into these areas be initiated. Furthermore, I am concerned that the guarantees for national industrial participation may not be sufficient. I will return to this conclusion by the Auditor General in 2000. However, the specific areas the AGSA probes in these paragraphs included the following areas where inadequacies were noted. Adequacy of performance guarantees, the National Industrial Participation or NIP, MOD policy, the armaments acquisition policy, the negotiation stage, the tender procedure, subcontracting, the negotiating phase, the budget, arithmetical and clerical errors. Once again, these are drawn from the original special review that then formed the basis for SCOPA's 14th report.
Right, thank you. Then in the following paragraph, you are talking about the meeting that of the hearings that were held by SCOPA, as well as the subsequent meeting that was held where you were invited to attend and discussions were held around the joint investigation team that should be constituted. And you do express a view regarding why it was necessary to have certain institutions included in this joint investigation team. Will you take the commission through that?
During October 2000, the hearings of the Standing Committee on Public Accounts with the Department of Defense, pursuant to the special review by the Auditor General South Africa of the selection process of strategic defense packages for the acquisition of armaments at the DoD, drew my attention, and I heard that SCOPA was going to hold a meeting with all the agencies involved. This would have included the National Director of Public Prosecutions, what was then colloquially known as the Heath SIU, the AGSA's office, and the Public Protector, mentioned in the 14th report on the arms deal at the AGA's offices in Pretoria, to discuss firstly their respective mandates and powers and how these could overlap and complement one another, as well as secondly the need for a proper budget for the investigation which SCOPA had called for in its 14th report of the committee, which the National Assembly had adopted.
The following paragraphs you talk about where, you know, where your interest lay with regard to this meeting and the SCOPA interaction relating to the issues of SDPP. And you also make reference to what happened, the engagements that the participants were involved in. And that is fairly in the public domain, and maybe we should then proceed to paragraph 27 of your statement where you make reference to specific legislation that you mentioned, the SIU Act. Please proceed to deal with paragraph 27 of your statement.
Thank you. It was during this meeting that my attention was drawn to sections of the Special Investigation Units and Special Tribunals Act, the founding legislation of what became known as the Heath Unit, in reference to Judge Willem Heath, who was the founding head of the unit, which provided for the unit to have the power to cancel contracts that were corruptly concluded. This is an important matter of detail to which I will return when I discuss the contractual invalidity clauses of the STP contracts, sections 20 and 22, which I believe have been declassified, and its link to this power of the Heath SIU. A copy of the Special Investigations and Special Tribunals Act is attached here too, and if I may refer to that.
Proceed to refer to that, but just before you do that, Commissioners, that annexure that the witness would like to refer to appears in pages 49 to 63 of the bundle, and in particular, she would like to draw your attention to pages 51 and 52 of the bundle.
Thank you, and I do so humbly in the context of those who are much better qualified than I am legally to reflect on these matters, but I humbly draw your attention to a number of clauses. The issues arise with respect to clause 4, 4.1c, 4.1d, and 2. As you can see, the Heath Unit has the power, well, let's just refer to the Special Investigative Unit and not deal with the colloquialism of the founding name, because that happens to be just coincidental. But when we're looking at the powers here, it's clear that the Special Investigating Unit can conduct civil proceedings in special tribunals, and that there is a very clear link between the Special Investigating Unit ability to also grant specific areas of civil proceedings, and then to have the immediate link with a special tribunal. I think that speaks quite clearly. And also the fact that there is a compulsion on the unit to draw to the attention of the prosecution service any issues in terms of the sections. And as you can see in Section D, to refer evidence regarding or which points to the commission of an offence to the relevant prosecuting authority, and in sub 2, a special investigating unit must, as soon as practicable after it has obtained evidence referred to in Section 1D, inform the relevant prosecuting authority thereof, whereupon such evidence must be dealt with in the manner which best serves the interests of the public. And if I may just dwell on this point, I attended that meeting as a member of parliament who had an interest in the industrial participation component of the deal. And because I had been party to a lot of the legislation that created some of the entities concerned. And it was a historic meeting that I also wanted to be present at to see how the discussion flowed. And there was a very strong discussion between the Auditor General's office and the representatives of the Special Investigating Unit, as well as the National Director of Public Prosecutions, about these complementarities as you can see them in the legislation in sub 4.
Thank you. Will you then proceed to deal with paragraph 28 of your statement, which deals with the contractual cancellation clauses that are part of the agreements that were concluded? Continue.
As the contractual cancellation clauses leave the agenda-setting power for cancellation largely in the hands of the sellers in the case of convictions for corrupt activities, it is an important element of the sovereignty of the South African state to recall that the South African state also had powers of contractual cancellation in accordance with its domestic laws, and specifically in relation to the powers of the then SIU, the Heath SIU. I attach copies of the relevant termination clauses of the SDP contracts in this regard as annexures.
And the annexures appear on pages 73 and 74 of the bundle. Would you like to take the commissioners to those specific pages and specific paragraphs or clauses?
Thank you. I would like to do so once again on the understanding that all these documents have been properly declassified as I have been advised. In terms of Section 20, if the seller or any of its members or representatives in relation to negotiating, entering into or execution of the agreement has been convicted of having committed an offence under the Prevention of Corruption Act or analogous legislation in any relevant jurisdiction by, for example, having promised or caused on its behalf to be promised, offered, or given any kind of illegal gift, illegal advantage, or illegal consideration, or been convicted of fraudulent, illegal, or criminal acts in obtaining or in the execution of the agreement, Armscor and the South African government acting together may summarily cancel the agreement and claim damages resulting from the cancellation, or claim an amount equal to 5% of the total contract price as agreed pre-estimated liquidation damages. The seller shall not, for the duration of the supply terms and for the period of 12 months after completion thereof, employ any employee or former employee of the South African National Defence Force or Armscor who is or was in any way involved with the agreement without the prior written consent of the Chief of the South African National Defence Force or the Managing Director of Armscor respectively or their deputies. DOD or DTI who is or was in any way involved with the agreement without the prior written consent of the Directors General of DOD or DTI respectively.
Right then, will you proceed to take the Commission through to paragraph 31 of your statement on page 10?
I'm commencing on paragraph 29. During the prelude to the opening of Parliament and the State of the Nation address in 2001, my then party leadership in the Democratic Party decided to shuffle the DP Scopa membership on the recommendation of a journalist. and appointed me to head the SCOPA team for the purposes of the committee's role in dealing with the strategic defence procurement question. Another consideration was the complementarity that exists between the work done in SCOPA and the work done in the Portfolio Committee on Finance, as these committee memberships were often held by the same party spokesman in the past. As a result, I became a member of SCOPA in 2001. It is in this capacity that I found myself dragged into the rapidly escalating controversy surrounding SCOPA and its arms deal probe. The controversy would impact executive legislative interactions quite severely.
Paragraph 31.
Thank you. It has only become clear to me, with the benefit of hindsight and following the receipt of further information, that at the time of the DoD hearing in SCOPA in October 2000, the DoD had written to Chairman Dr. Gavin Woods, pointing out that some of the questions SCOPA wanted answers to could not be answered by the officials of the DoD, but would have to be answered by members of the Interministerial Cabinet Committee and Cabinet, as key final decisions about specific equipment selections were made at that level. This did not occur before the adoption of the 14th report of the Standing Committee on Public Accounts, and became a subject of criticism of SCOPA, which the ministers concerned levelled in a press statement in early 2001, and again when they finally did appear before SCOPA in February of 2001. The press statement released by the ministers and the transcript of the proceedings before SCOPA are attached hereto.
Right, and the transcript appears on pages 12A to 219 of the bundle, Commissioners, and RT8, the minister's press statement, appears on pages 101 to 102. Now, in respect of RT9 in particular, is there anything that you'd like to bring to the attention of the Commissioners?
Yes, there is. I'd like to draw the attention of the Commissioners to page 108 of the transcript. And just to point out, for accuracy, I believe this may be the Minister of Finance speaking, or I just want to clarify. Yes, it seems to be. And I'm quoting from the third paragraph. This means, and I think it is an important point, that 4 departments and 4 ministers were immediately involved, and we were chaired by the then Deputy President, subsequently President Thabo Mbeki. This means that the evaluation process, which was examined by the Auditor General and in the questioning of SCOPA, is not identical to the decision-making process. The decision-making process was informed by that evaluation, that the decisions were taken by a cabinet subcommittee making recommendations to the cabinet. This is important from our viewpoint because it means that we had structured the process in a manner that meant that many players were involved in the decision, and this was done explicitly to ensure that we could manage this decision in the optimal manner. I am dwelling on this issue because, to the best of my subsequent understanding, the documents that were provided to the Standing Committee on Public Accounts are indeed the documents of the Interministerial Cabinet Committee, and they're not fully fledged cabinet documents, and it is something that also arose in the hearing of SCOPA. That is my impression, and this is why I believe it important to raise it with the Commissioners, because it is of significance, because SCOPA interacted with these documents in the belief that these are not the Interministerial Cabinet Committee documents alone, but the actual fully fledged cabinet discussions on the overall procurement. And I think it's something that I also want to draw the Commissioners' attention to.
I'm sorry, Ms. Lamkha. Let me just understand what the witnesses say. Are you saying that the decisions were not taken by cabinet, but then they were taken by interministerial committee? Or what I said, maybe I misunderstood you.
Mr. Chairman, I'm trying to clarify that the Interministerial Cabinet Committee minutes were the documents that Mr. Sheikh sent to Dr. Woods, to the best of my understanding. And I believe those are the documents that have been declassified.
Proceed then to the next paragraph.
Is the best of my understanding, based on my interactions with the evidence leaders.
Will you please proceed?
At this point, I have to indicate that these reflections on events are reflections tinged with an awareness that I was a member of the opposition political body politic at this stage. As the ranking member of the opposition in Scopa, during this process, it was required of me to try and ensure that the political party that I represented attracted sufficient media coverage for its work on this matter. Some of the testimony that I give will therefore reflect those perceptions of that time from the vantage point that I then held, that of a member of the Democratic Party, which subsequently ceased to exist as a political party during the period when the DA was formed. I will be mindful of Section 9(2) of the Electoral Commission Act as I do so. During this period, the chairman of Scopa and I tried to ensure that Scopa would have some interactions with the investigating teams. These interactions became sporadic and bogged down in legal discussion about the powers Scopa did and did not have. Similarly, the Standing Committee on Public Accounts as chairman had crates of documents which were sent to him by the DOD, which were subsequently transferred to Madam Speaker in early 2001 and to Parliament, where they would be held under lock and key and where they became legally protected by the powers and privileges of Parliament. The documents were sent to Dr. Woods by Chief of Acquisitions, Chippy Sheikh, and he later wrote back to Dr. Woods indicating that he did not have the approval of Cabinet to release the sets of Cabinet documents that he had sent to Scopa and to the committee, therefore. A letter from Mr. Chippy Sheikh to Dr. Woods is attached hereto as Annexure RT10.
RT10 appears on pages 220 to 221 of the bundle. You may proceed. Do you want to refer to the letter, the contents? Yeah. Please proceed to paragraph 37.
Thank you. I think it's best if other witnesses perhaps refer to the detailed content of that particular letter. Thank you. These documents also became the subject of legal wrangles as specific rules, specifically Rule 157 of the Rules of the National Assembly, governed the use of these documents, and due to their classified status, members of Scopa could not take notes or quote from these documents at any stage. This created difficulties in being able to pin ministers down with specific questions in accordance with the constitutional provisions of executive accountability to the legislature, as MPs who had read these documents could not freely quote from them in asking questions to ministers. However, members of Scopa could spend time reading these documents and using them as a basis for parliamentary questions as well as debates, both of which I did, as they revealed critical areas of breakdown in ministerial responsibility, as well as in legislative-executive interactions under the provisions of the new Constitution of the Republic that was signed into law by President Mandela in Sharpeville on the 10th of December 1996.
Now, in this paragraph, you say that this revealed critical areas of breakdown in ministerial responsibility as well as in legislative-executive interactions under the provisions of the new Constitution. Would you please elaborate on that portion of the statement?
If I may then, with the indulgence of the commissioners, go beyond the areas that deal with the issues in sub D. I'm just asking for guidance from the evidence leaders.
Yes, you may, if it contributes to a smooth flow of the evidence presentation.
Thank you for the clarification. I then turn to page 15 where these issues arise. Under the heading Ministerial Responsibility, Collective Responsibility, Chains of Accountability Broken, the Interministerial Cabinet Committee, the role of Mr. Sheikh, the IONT, and the terms of reference of the IONT. It is as a consequence of having had sight of these documents that it became clear that various chains of accountability broke down during the strategic defense procurement process. And as you will know from the statement, these reflect my knowledge, and my perceptions on these documents. Some, though not all, of this can be attributed to the fact that certain laws of the apartheid era, for example, the Exchequer Act, the Defence Act, had not as yet been brought into line with the new constitution. However, there are clear breakdowns that cannot be explained by these factors alone, given that new constitutional standards were in place, setting a higher standard as a matter of legal and, some would argue, moral principle. A further number of structural aspects have to be mentioned before breakdowns are highlighted. Firstly, the South African Defence Secretariat is responsible for acquisition, and the key role players here are the Secretary of Defence as the accounting officer and the Chief of Acquisitions, who is responsible for the industrial and procurement policy for the DoD. The Defence Secretary chairs an armaments acquisition steering board, which approves non-cardinal projects and screens cardinal acquisition projects. The Secretariat grants contracts at the highest level and does not deal with subcontracted suppliers. Arms Corps manages all acquisition processes for the DoD and remained under the MOD after the 1992 restructuring of Arms Corps/Denel, with Denel taking control of the local defence industry, falling under the Ministry of Public Enterprises. These breakdowns therefore contain important lessons for future procurements, whether in defence or in large-scale infrastructure projects. Another issue that is of crucial importance is to note that the country's arms acquisitions policy actors did not have any experience in running a strategic arms acquisition package, as past arms approaches and procurement decisions had been on a case-by-case basis, as has been pointed out by DoD officials here and indeed at the public hearings of the Joint Investigating Team in 2001. It is important to differentiate a strategic arms procurement acquisition, such as the Strategic Defence Package, from others, as it is a rare and expensive acquisition that becomes the responsibility of a country's executive and or legislative branches of government, mindful of civil-military relations dimensions. And if I may just also draw the Commissioner's attention to a very good academic piece of work by Justin Sylvester and Annette Seegers on these issues, which will be of assistance also to the Commission. And I'll happily provide those references in due course.
Yeah, maybe let's just leave out other books because, this is not direct evidence. She's not going to quote from another book. I'm not quite sure if that is going to help us. This next paragraph, she deals with other people's works. I'm not quite sure how helpful that is going to be. But Ms.
Mr.
Schumacher,
Chair,
just hold on. I'll leave that in your hands.
Thank you, Chair. May I just, the book that you'd like to refer to? It's in the bundle. Am I right? It's in the bundle. It's not in the bundle. Well, that in itself, I think, to an extent, creates a problem. If there's any further literature that you are of the view that it can be of assistance in the work of the Commission, I think without imposing it on the commissioners to read or to look at, it would just help to get a script on that, and that's it, as to how it will feature, if at all or not, it's something that is not within our control. Yes. It would be a bit difficult for us now to start introducing other documents. And I think maybe then at this stage, the indication that we are getting, and which is of course correct, is that the Commission operates within the 4 parameters of the terms of reference. And the Commission's main interest is how the evidence that is being presently presented, how is it going to assist the Commission in the execution of its function with reference to the very terms that we are talking about. And I think when we come to deal with the contents of the book, most of the issues of interest will then come up at the time. So in a way, it's actually maybe not even necessary to go through the entire statement verbatim. Like I have said, you can read into the record what is important and even speak to some of the provisions or some of the paragraphs in the statement to highlight issues that the specific paragraphs seek to address.
I will be looking for guidance from the chair because the book is not, I haven't sworn or affirmed the text of the book. I have the statement.
Yeah, I think now in terms of the statement that we have, it's not sworn to, and it was also not taken under affirmation. The book is a public document. It will be weaved into the evidence that you'll be presenting, and you'll deal with the questions like you've said. You'll be led by the evidence leaders, and you will then respond to the questions as they are put to you in line with what is contained in the book.
I don't, Mr. Chairman, want to turn this into a lengthy or verbose procedural conversation, and I have very comfortably worked with my evidence leaders up until this point, and I hope that we will continue to do so throughout the course of the day. The issue for me is there are complementarities between the statement and the book, but obviously one is at greater liberty to write in a book which is in the public domain and has been checked up and down for defamation. But I have a very clear desire to share the issues which I have sworn to in the statement. And you will clearly notice, if I may proceed, that there are complementarities, strong ones, between the book and the statement. If I may do so, I will naturally not try and not deal with the book. In fact, there are areas where I would like to specifically refer to annexures in the book that are relevant to my statement, and I will do so. So I don't want us to belabor process, but I want to be clear that I have certainly sworn and affirmed my written statement with its annexures, and I'm very happy that I did so. The book, to the best of my understanding, does not form part of that. But I'm very happy to deal with the complementarity issues. But I also don't want to just get stuck on procedure.
With your permission, Chair, I would like to ask just for a short adjournment. At the beginning of the presentation of evidence, we did not place it on record that the witness has not been legally represented throughout, from even the time of consultation up to now. And it becomes our responsibility to ensure that there is some level of comfort on the witness's part. And I will thus just request that the Commission just grant us an indulgence just to discuss certain issues and then come back. It will not be a long discussion that we would like to hold, and we will try to avoid asking for stoppages during the presentation of the evidence.
Will 10 minutes be okay? Or 15?
15, please, Chair.
15 minutes?
Yes.
Okay, we'll adjourn for 15 minutes.
Right.
Thank you.
Thank you, Chair.
All rise. Can the witness confirm that she's still under oath?
I do.
Thank you. Mr. Omaka.
Thank you, Chair. We have conversed with the witness, and we would like to request that in the presentation of the evidence, we perhaps stick to the chronology of the order of the statement. The next area that we were going to deal with after dealing with the executive responsibility breakdown would have been the contractual validity questions and corruption issues. Now, that appears on page 12 of the statement. We request that the commissioners, the chair, cognizant of the fact that the witness did not have a private legal representative when this statement was developed, we request then for the indulgence that the witness be allowed to go through her statement in the order that it is arranged, and an attempt to bring in other documents that are not part of the bundle will not be made, and if a need is identified that certain other documents be introduced to the commission, the team will try to find a way of dealing with that, but in a proper way. Thus, I request that then the witness resumes the presentation of evidence starting from page 12.
Okay, thank you.
Thank you, Chair.
Thank you, Mr. Chairman. I think we're all trying to make progress in good relations. So let's proceed then from page 12. I'm proceeding from D. Contractual validity questions and corruption issues, an umbilical link. As I have already indicated above, the question of the multi-agency probe that was recommended in SCOPA's 14th report had a bearing on the inclusion of the Heath unit specifically due to its powers and its ability to cancel or set aside corruptly concluded contracts. It had already at that stage done so with respect to contracts for the provision of social grants in the Eastern Cape prior to the creation of SASSA as a national distribution agency and the centralization of such payment systems to curtail corruption. The presence of, and I should start referring to this as the SIU, was therefore crucial. This is so as the contracts themselves left the ability to initiate nullification due to a corruption conviction in the hands of the suppliers, and furthermore provided for immediate invalidity if acts of revolving door employment occurred with any of the officials involved in the procurement itself, commencing work for a supplier. This happened in at least one case, which is referred to. It's therefore important to understand that in terms of South African law, it would have been possible to cancel contracts.
I'm sorry. I suppose as and when you go along, we'll stop in order to get some clarification. Here I see you're saying that in paragraph 40, you talked about there's a revolving door employment having happened at least in one case. Can you refer us to the relevant portions of your attachments?
With your indulgence, Mr. Chairman, we did compile these this morning. Chair, it's by implication included in the issues that relate to the Corvette agreement in 7 and specifically the termination clauses there.
Clauses, Chair, appear in pages 73 and 74. Let me just check.
Mr. Ramachar, I'm aware of that, but then the statement says here that this happened in at least one case. That's what we're trying to find. Which case is she referring to? Is there any reference to it in the annexures that that we have been provided with? Or can the witness explain what she means when she says that it happened in at least one case, and give us full details of that incident, because we'll be quite interested in that.
Right. Thank you, Chair. Will you please elaborate on that?
Mr. Chairman, I think it's important to point out that it's not a case, again, of which I have personal knowledge. It was an allegation.
What is the allegation?
It's part of the allegations that were contained in the documentation, I think the documentation otherwise known as the DeLille dossier, relating to a member of the Navy who was working with the German frigate consortium.
Who's that member of the Navy?
Mr. Chair, these are allegations.
I understand there are allegations, but then those allegations have been made and a person has been named, as you say in this statement. So the question is, who is that person who has been named? We know that it's an allegation, but then we want to know who is that person so that we can go after that person, because this is what we're trying to find out. The major portion of this commission is to try and find wrongdoing. But then if you are aware of a possible wrongdoing, please give us the details. We want to know who that person is so that we can approach that person and confront that person if necessary.
Mr. Chairman, this person's name has been circulated in the media, but because I don't have any personal knowledge specifically, I will not do so. And I have interacted with this process in good faith without legal counsel. If I believe that becomes necessary, I may change my mind.
To be honest with you, I do not understand that. If you say in the papers that this person has committed a misconduct, and you say the name has been given to you, when we say to you that give us that name so that we can be in a position to follow up that person, if you told a person who was a Navy member acted contrary to the to terms of employment and to the supply terms that GSC entered into with the South African government, we'll want to follow up that person. But then if you only say that you can't even give us the names, you can't even give us the details, I'm sure there's very little that we can do. We can't force the information out of you, but then I can assure you that is not helpful at all. It would have been much better if you told you were in a position to give us the name of that person, because I'm sure we would have tried to subpoena that person and then come and explain. But then if you don't give us the name, then we can't subpoena that person to come and explain. But then if you prefer not to give us any details and you just continue reading this, I'm sure you can go ahead. We can stop you.
I'm in your hands, Mr. Chairman. I'm also aware of the fact that the DeLille dossier has been given to the Sariti Commission for investigation. And as this name arises in the DeLille dossier, I'm sure that the Commission will be looking into these issues, and I will continue to read my statement, with your indulgence.
May we proceed, Chair?
You can proceed. I've made my point.
Thank you. Right. Will you then proceed to paragraph 41 of your statement?
I will proceed to paragraph 41 of my statement. It is therefore important to understand...
Let me interrupt you. You see, the difficulty I have here is that in this very same paragraph, the paragraph says that, and furthermore provided for immediate invalidity if acts of revolving door employment occurred with any of the officials involved in the procurement itself commenced working for a supplier. This happened in at least one case. Now, that is a statement of fact, that. And the question is now, which instance are you referring to here? And you are talking of the Delil dossier. The Delil dossier contains no evidence. It contains only allegations which the author of the Delil herself cannot substantiate. You probably are aware of that by now. So to say here, this happened in at least one case, when there is no evidence of such one case, is truly misleading, isn't it?
With all due respect, I actually want to take this matter up as well with the evidence leaders. I've had very little time to review the final formatted statement which I received from the evidence leaders. And I think that it is critical, also in the interests of my rights and my reputation, that I clarify with the evidence leaders the version of the statement that I sent to them and the version of the statement that was formatted and sent back to me. And I don't know whether you would like another adjournment while I do so, but I would like to request the opportunity to do so, because I will feel very uncomfortable if I have to leave this room with an assumption that I am making unsubstantiated allegations, and that can be attributed to an editing issue between myself and the evidence leaders.
I understand what you're saying. This is a statement, and basically you're asking questions about what you have already read. This is contained in your statement. I'm not quite sure this point that you're raising now, where does it emerge from? The question is, you say that one person at least has been mentioned who was employed by GSC when he was not supposed to. The simple question is, who is that person? We want to follow up that person. We want to subpoena GSC and ask them to come and explain why they did that. Now, if you say to us, I can't tell who that person is, that is not helpful at all. But in any event, if you want an adjournment, you can look at your statement again. If you want to say that you didn't have a look at the statement again, we're prepared to give you that opportunity. But then just keep in mind that we want to know what actually happened. We're trying to find out if there's any person who was involved in any criminal conduct. If we do know that person, if we do mention them here, you can be rest assured we're going to ask you questions about it, because we want to approach those people and try and get answers from.
Mr. Chairman, which is the reason why, in the interests of fairness to myself and in the interests of fairness to the evidence leaders, with the timelines that we had at our disposal, in the time period that I've had to deal with this issue, I would like to request the opportunity to do so. And I'm sorry if we're going to keep adjourning, but I'm going to ask for that opportunity because I had very little time this morning to ensure that the version that I emailed and the version that I finally signed was page by page, clause by clause the same, or whether there was a formatting or editing issue that may have arisen this morning, because we were still working on this morning. And I think it's in the interests of fairness to my rights as a witness, and also in the interests of fairness to you in seeking the answers that you would like to have, that I do so.
Mr. Auditor, will give you all the chance that you need in order to enable you to give us proper evidence which might be helpful to the Commission. If you do want an adjournment, we'll grant you an adjournment. We're here to hear your evidence. What sort of time do you have in mind?
Mr. Chairman, if you want to step away from this point and I can consult with the evidence leaders during the lunch period, we can do so. And I'm very happy then to consult with them and to come back. But I'm also very happy to provide you with the evidence that I do have. which is the table of ongoing investigations and issues on page 22 of the JIT report. But I'm not sure whether I'm going to be helpful as a witness to you in this regard, or whether Mr. Deploy and the former members of the Scorpions are going to, now Hawks, are going to be of assistance to you. But I'm happy to leave that with you.
Mr. Elder, let me assure you, we are aware of those allegations. We are aware of the JIT report. We have read the JIT report. Some of us have read it even more than twice. We are aware about what the Hawks have done. We had a meeting with them. We know exactly what they have done. And I can just mention it to you that one or two of those members of the Hawks will be called as witnesses. So we are aware of those investigations. I'm not sure if that is helpful to, if you know that, you know, we are aware of the JIT report. We have read it several times. We are aware of what the Hawks have done. In any event, one or two members of the Hawks will be called as witnesses.
I'm delighted to hear that, Mr. Chairman, and also greatly gratified by that.
So do you still need some time to talk to the evidence leaders before you proceed with a statement? And if so, I was just trying to find out more or less how long do you need, 15 minutes, 30 minutes, so that we can know what time should we come back.
I will come back to this issue, if I may, after the lunch break, but I am in your hands in terms of guidance.
Okay, we can proceed. You know, because of the time that we lost in the morning, I thought we'll break for lunch at 1:30. Will that be okay, Ms. Mamaka?
Yes, that'll help, Chair, because, I mean, the witness makes it clear that she is, to an extent, comfortable with her statement, but if there are any, you know, sort of allegations or things that are said in the statement that she believes she might not have said, that would be clarified, or she would stop at the time and then want to really do the comparisons then. But her indication presently is that she is in the position to can then proceed to present her evidence with the statement as it is.
Thank you. Thank you. We can proceed.
I think it's important, Mr. Chairperson, and thank you also to the evidence leader, because I think there are issues that I will look at very carefully during the lunch break with respect to the entire statement. Thank you. But we'll proceed with the areas that deal with the corruption issues. I just want to proceed then from paragraph 41. And bearing in mind, as I said from the beginning, I am interacting with this process in good faith without legal counsel. It is therefore important to understand that in terms of South African law, it would have been possible to cancel contracts due to the involvement of the SIU. It's also critical to reflect on the constitutional standard that was set out in section 217 of the new constitution, and its call for transparent and fair procurement. It's important to bear in mind that this clause called for that. This clause has recently been bolstered significantly by the Constitutional Court's ruling in the All-Pay case. In this case, it was not even necessary to establish corruption for the social security payment system of SASSA to be found wanting and the contract to be declared invalid. A simple non-compliance with the procurement prescript that resulted in an outcome that breached Section 217 was sufficient. As the new constitution was in place at this time, it could also have been used as a standard to bring about contractual cancellation. It's also important to note that even the payment of so-called commissions in the arms trade is outlawed by the OECD Convention on Combating the Bribery of Foreign Public Officials. As the bulk of suppliers are OECD states, they are bound by these provisions, and convictions for the commissions that they paid would have been possible in either their jurisdictions or in South Africa due to the provisions of the Corruption Act as well as the activities of the SIU. Please note, would have been possible. This is further bolstered by the public international law commitments that exist in terms of the UN Convention Against Corruption. I attach relevant excerpts of the OECD Convention as Annexure 11.
Is on pages 222 to 262 of the bundle. And would you like to bring the attention of the commissioners to particular clauses in this document?
Well, the entirety of the convention, naturally, but I also just want to pick up on a point that is relevant on page 246. Where there are also recommendations that are relevant to the issues that the Commission is going to be looking at. And it arises with reference particularly to the export credit guarantee agencies. In accordance with the 1996 Development Assistance Committee recommendation on anti-corruption proposals for bilateral aid procurement, member countries should require anti-corruption provisions in bilateral aid-funded procurement, promote the proper implementation of anti-corruption provisions in international development institutions, and work closely with development partners to combat corruption in all the development cooperation efforts. I raised this issue because in terms of the provisions that apply also to export credit guarantee agencies, there is a significant discourse with respect to the DFID and whether or not there ought to have been an export credit guarantee agency form loan. This is why the issues in the OECD Convention are particularly important as they relate to the supplier countries, because the financing came from export credit guarantee agencies in countries that were also significant donors of aid in the initial years of our transition to democracy, particularly EU states.
Then continue to paragraph 43.
It's also important to note, even though this falls beyond the time period of the relevant procurement, but it is an important issue to note in the evolution of our law on these matters. In 2007, South Africa ratified the OECD Convention, and under these provisions, as well as the new Prevention of Corrupt Activities Act, as well as the ongoing activities of the SIU, the architecture to combat bribery has been significantly bolstered. It should furthermore be noted that the purposes of dual criminality and mutual legal assistance, the architecture that exists today of the new domestic law, and arguably some of this was in place with the Corruption Act of 1992, the Prevention of Corrupt Activities Act attached hereto as annexures R12 and RT13, as well as the OECD and UN conventions respectively, would be of significant assistance to the Commission if it were to take the schedule of ongoing investigations contained in the JIT report on page 22, as well as the matters contained in the case files, which the Hawks have further. And I've already referred to page 22 of the JIT report. If, with the indulgence of the evidence leaders, I may just refer to the clauses of the Prevention of Corrupt Activities Act that I'd like to draw the Commission's attention to in order to make the point about the evolution of our law during the process of the ongoing umbrella agreements and supply terms and delivery terms of these contracts, which were long-term contracts and stretched over a significant period of time. I will do so now. If you look at the Prevention of Corrupt Activities Act, and I'm referring specifically to the bundle, pages 274 onwards. If you look at the general offences of corruption, but more particularly, if you look at the offences that are contained in Part 2 of this legislation, related to offences in respect of corrupt activities relating to public officers, it's important to note that this legislation was drafted in 2004, that the UN Convention came into play in 2005, and that for the entire duration of the continued delivery schedules as well as financing components of this agreement, these international law obligations and domestic law obligations that are mutually reinforcing will reinforce one another and ought to be of great interest to this Commission in pursuing its mandate.
Right, thank you. And will you then proceed to page 15? You have partly dealt with the heading relating to the ministerial responsibility, collective responsibility, right? Will you then proceed to where you had left? I think you dealt with paragraph 46, 47, 48, 49, 50. I think you are supposed to deal with 51. Speaking under correction. Yeah.
50, if I may. And the issues are quite relevant because the areas of decision making and where the opportunities with respect to decision making arose is critical. Paragraph 50. Another issue that is of crucial importance is to note that the country's arms acquisition policy actors did not have any experience in running a strategic arms acquisition package, as past arms approaches and procurement decisions had been on a case-by-case basis, as has been pointed out by the DoD officials that have appeared, and the public phase of the JIT investigations in 2001. It's important to differentiate a strategic arms acquisition, such as the SDP, from others, as it is a rare and expensive acquisition that becomes the responsibility of the country's executive and or legislative branches of government, mindful of civil-military relations dimensions. The first link that broke down was that of civil-military relations in defense procurement matters, where the executive branch of government was an active and, according to some highly rated academic authors, if not dominating participant in the strategic acquisition package, negotiating directly with foreign governments, like the United Kingdom and Germany, who are South Africa's main European trade partners and sources of foreign direct investment. The strategic acquisition package was a means to attract foreign direct investment and to gain access to foreign markets. Whilst this is to be partially expected in a project of this nature, especially given the timing at the end of the Cold War, as South Africa was emerging as a new democracy with a need to build ever stronger trade ties to escape the stranglehold of the aftermath of apartheid and to reintegrate the economy into the global economy, the level of involvement of the executive branch in defense procurement decisions to the point where the Hawk was chosen against the preferences of the Secretary of Defense and the chiefs of the South African Air Force is an important issue to note, and I'd like to refer to the relevant document, if I may, that's in the bundle.
The RT15 is in pages 312 to 317 of the bundle, and I believe the witness would like to refer to page 317.
Thank you. I would like to do so, and once again I do so on the understanding that the declassified stamp is as reliable as I believe it to be, Mr. Chairman. Paragraph 7.3.24, and I would like to read. The Minister said the political decision needed must not revolve about the operational aspects of the aircraft, that it is part
Just
of...
hold on, ma'am. Just when you read a paragraph, give us a chance of getting into that paragraph. We're still trying to find that paragraph. Which paragraph is that?
My sincere apologies, Mr. Chairman. It's on page 317 in my bundle. I hope that my bundle is exactly the same as yours. And it is paragraph 7.3.24 on page 317. Are we on the same page? Thank you. The Minister said the political decision needed must not revolve about the operational aspects of the aircraft, that it is part of our recommendation. Government must decide if they want to enter the European market, and if so, through which partner. The defense industries of the world are forming consortiums. If we are not part of one of those consortiums, our aircraft industry will be lost. He said we must not prejudge, let the politicians decide. I simply draw out this paragraph because there are nuances here in terms of civil-military relations that are quite critical to this commission in reflecting on the decision points and the roles and responsibilities between the various committees, SOFCOM, the Arms Acquisition Board, the Ministers, Interministerial Cabinet Committee, and indeed Cabinet as a whole. Those decision-making points are really very relevant to the deliberations in this commission and to its recommendations.
Right, thank you. Then you may proceed to paragraph 53.
According to these scholars, this clearly demonstrated, at least in part, the eagerness of the new administration to grant a significant contract to a British company. But the breakdown goes deeper into the very core of the civil-military relations discourse in defense procurement matters. And I do believe this is a policy issue that the Commission ought to consider, mindful of future procurements, if I may say as a suggestion, Mr. Chairman. The second chain of accountability that broke down was that of ministerial responsibility, given the significant scope that was granted to the International Office negotiating team, in relation to the decision-making processes of the Interministerial Cabinet Committee on the Strategic Defence Procurement Package. The terms of reference that were given to the IONT and the Chief Negotiator specifically were, in my view, a near abdication of collective cabinet responsibility, as the widest possible negotiating power was granted to the Chief Negotiator. And I fully accept that this is my view and my view only. I attach a copy of the relevant terms of reference as Annexure RT16.
RT16 appears in pages 318 to 320 of the bundle. And is there any specific provision in the terms of reference that you'd like to bring to the attention of the commissioners? And if so, in which page is it?
I would just like to once again clarify with the evidence leaders the declassification issue of this document. I did raise it this morning. This is a declassified document.
Yes, Chair, the document has already been handed up through the evidence, I think, of Mr. Naidu.
Thank you. There is indeed on page 318. I'd like to just draw attention to the wording that was also amended. The Chief Negotiator reports to the Ministers' Committee and to the Deputy President as required. You will notice that from the paragraphs that follow, it's a very wide role description for the role of the Chief Negotiator, and it embraces various areas of defense and trade in a coordinating role. And you will notice specifically that the Chief Negotiator is located in the Ministry of Defense. And the reason why this is important is when you look at the composition of the International Office negotiating team itself, you will notice that it has extensive representation from the Department of Defense as well as the Department of Finance, the Department of Trade and Industry, and only one representative in the IONT from the Department of Finance. I want to bring this to your attention because it's quite critical to the moment in which the financing issues of the deal actually received greater attention at cabinet level, and I hope that that will emerge as we proceed from the statement. But it's very important to see this in context, to also see the role of the Chief Negotiator in the very broad terms of reference that were given to the Chief Negotiator.
Thank you. Proceed then to paragraph 55.
There were further misalignments between the work of the International Office negotiating team and the affordability team that was belatedly engaged to sufficiently ascertain the full possible macroeconomic risks of the large-scale procurement. However, the testimony of Roland White before the public phase of the Joint Investigating Team's hearings in 2001 also clearly showed the number of instances where the Department of Finance took a slight backseat during the technical scoring at SOFCOM stages, including when costed and non-costed options for the hawk were being considered. The affordability team's reports and work came into the process fairly late, when the International Office negotiating team had all but concluded core elements of negotiations and prices. I attach a copy of the transcript of Roland White's evidence at the JIT hearings as Annexure RT17.
Now, RT17 is in pages 321 to 378 of the bundle. And you'd like to draw the attention of the Commission to a specific portion of this annexure. Please go ahead.
Thank you so much. I would like to draw the attention of commissioners to page 323. Thank you. As you will notice in the transcript on page 323, this deals with memoranda that were sent to the then Minister of Finance by Mr. Roland White relating to the financing of the strategic defence procurement and the status of these memoranda that was sent to the Ministry of Finance. These are exceptionally important documents which I believe this Commission ought to have in order to reflect on the cost issues related to the procurement. If I may continue. In terms of the consultation, both the Constitution and the Access to Information Act and the internal memoranda by advisors are privileged. We cannot accept, with exception for the accessing, which in particular case, given the fact that I've already indicated that we understand it is the Auditor General investigation, the only exception that would be there would be in terms of Section 281 of the Companies Act, alternatively in terms of Section 5 of the Auditor General Act. I think the issues here, as I indicated, specifically relate to the memoranda that were written to the Minister of Finance. And I highlight this because the critical issues of the cost and the affordability of the deal and the decisions that were made are reflected in the memoranda. And if I may just turn to the book for a moment, because I don't want to disappoint the chairperson that we won't deal with the book at all. We will deal with the book and key areas of the book. On page 251 of Up in Arms, there is a copy of a letter which I addressed to the then Minister of Finance requesting access to these memoranda. Because they are quite critical with respect to also questions in terms of when contracts were signed, when contracts were initialed, issues that undoubtedly will arise in the context of this Commission's further investigations. And I'd also like to turn the Commission's attention to page 257 of Up in Arms, which contains a reply from the Ministry of Finance highlighting the request not being acceded to for the memoranda. I'd like to submit to this Commission that it is in fact of critical interest to this Commission to have access to these memoranda, and they could easily be made available if the public interest provisions of the Promotion of Access to Information Act were to be used.
Right, then you may proceed to deal with paragraph 56. It's on page 18 of the statement. I'm on page 18, paragraph 56. The chief negotiator became in effect a second in command to then Deputy President Mbeki and eventually to the then Deputy President and eventually President Mbeki. The press statement announcing the chief negotiator's appointment issued by the Office of the Deputy President made this quite clear. The chief negotiator was on contract to the Ministry of Defence, but his tasks were wide-ranging, and the statement states that since his task will involve activities that relate to the Department of Defence, Finance, Public Enterprises and Trade and Industry, Naidu will be accountable to and report to Deputy President Thabo Mbeki. I attach a copy of the press statement of the then Deputy President Thabo Mbeki as Annexure RT18. The annexure will be found at page 379 of the bundle. You may proceed to the next paragraph, 57.
Whilst this Commission has therefore heard much about collective cabinet responsibility, I would urge you to go much deeper to understand the roles and relationships between the chief negotiator and members of the cabinet and the IMCC process better. The conventional notion of collective cabinet responsibilities where ministers fully engage on the detailed trade-offs inherent in different policy choices and balances between policy choices. I would argue that this was not the case in this case, and this has a bearing on the notion of collective cabinet responsibility that we have been confronted with. This only becomes clear when one fully considers the terms of reference of the chief negotiator's position, as well as the various sets of minutes of the interministerial cabinet committee meetings where this role can be clearly assessed. Whilst the chief negotiator was on contract to the Ministry of Defence, his role goes far beyond what a civil servant at any level of seniority would ever have had. In this regard, it also goes much further in highlighting the breakdown of accountability if all the normal mechanisms of accountability, where the constitutional provisions can reach, are largely effectively curtailed by such an appointment, despite the provisions of sections 55 and 56 of the Constitution, that could arguably use to secure all necessary information about this role. Herein lies a lesson for all future large-scale and complex government procurement processes, whether in the defence arena or any other, regarding the role of such a post and its remit and its impact on notions of accountability. The third chain of accountability that broke down was the inappropriate role played by the Chief of Acquisitions of Arms Corps in a variety of fora, not least of which acting arguably highly inappropriately as a cabinet secretary in preparing minutes of the interministerial cabinet committee meetings, the minutes that were handed over to the Standing Committee on Public Accounts prior to its October 2000 hearing with the Department of Defence on the strategic defence procurement.
Why do you say that for the Chief of Acquisition of Armsco to become the secretary or the cabinet secretary for the moment in relation to the IMCC was irregular or improper? Why do you say that?
Because it's an unusual role to be playing vis-a-vis an interministerial cabinet committee.
Just on Ms. Lamaka, are you aware that one of the evidence that we have is to the effect that he was requested to play that role? He prepared the initial minutes, circulated them, inputs were made, and he returned them back to the various ministers, if you are referring to the meeting of the 31st of August, 1999. Are you aware of that evidence?
Mr. Chairman, regrettably, I haven't had the opportunity to follow every detailed element of these proceedings. We have earlier today referred to another role that I do have, and you'll also recall that this year is an election year and was an election year, and commissioners were quite engaged with the national and provincial elections. So regrettably, I have to say that I didn't spend as much time, even though I spent a considerable amount of time following your proceedings. I did not follow that element of your proceedings. And this is my impression, and it's an impression that's also informed by the field of public policy in which I teach, in terms of the arrangements that would govern cabinet minuting, cabinet relations, cabinet decision making. I would still consider it arguably an inappropriate role.
Just for the completeness of the record, Chair, may I just indicate that the IMC minutes, I think it's 4 sets that have been handed up, and all of those minutes are actually scribed by the Chief of Acquisition. So it's something that just runs through the entire, it's not just a once-off thing that happened. I'm just placing on record just for the completeness of the record. Thank you. Please then proceed to the next topic, which is executive-legislative interactions and constraints.
Thank you. I'll try and speed up so we have enough time for consultations during the lunch period. We cannot equate the white paper and the defence review with the SDP, according to scholars Sylvester and Seegers. They point out clearly that those who state that Parliament approved the defence review and therefore approved the SDP are wrong. Instead, it is the other way around. The defence review became a legitimizing mechanism for the strategic defence procurement. It is important to recall that Parliament approved a document that contained several options. What Parliament approved was an ideal image of the South African National Defence Force design, subject to budget constraint, and as the review contained no details of the exact cost of the various options to the state's budget, an argument cannot be sustained that a parliamentary approval of the defence review equates to an approval of the SDP. There are two further technical arguments that are, however, relevant. Firstly, whilst it is true that the Exchequer Act was in force, which allowed a significant amount of budgetary discretion and executive sway in the hands of... Sorry, it seems to be a misalignment of pages here. The ones in my file are not as well marked. This must be seen in the context of the adoption by Parliament of the Public Finance Management Act in 1999 and its entry into force on 1 April 2000, as well as the adoption of the new constitution in 1996 that set a new standard in terms of Section 217 on government procurement. Whilst the PFMA implementation date falls beyond the period of contract conclusion for the SDP, the overall legislative direction was clear, and the new constitution clearly provided for a role for Parliament in the budgetary process. Whilst this legislation also came about much later, the Money Bills Procedure and Related Matters Act of 2009, the fact that this provision was in the new constitution clearly meant that provisions in Schedule 6 of the constitution would have had a bearing on at least posing the question whether such executive concentration of budget powers in the hands of the Minister of Finance was desirable in such a controversial procurement, such as the unusual strategic defence procurement package. Whilst the National Assembly undoubtedly voted on the defence budget in the estimates of national expenditure of the budget, therefore giving credence to the basic technical approval of the SDP, or what passed for the estimates of national expenditure in terms of the Exchequer Act, therefore giving credence to the basic technical approval of the SDP in parliamentary terms and loan agreements, such approval and debt exposure should have warranted more than a mere passing engagement for the legislature, given the importance of the executive branch's foray into the civil-military relations demarcation in the procurement space. The relationship between the Standing Committee on Public Accounts and the ministers ought to also receive a small mention. The ministers criticised the Standing Committee and its 14th report on the strategic defence procurement quite aggressively in a press statement in January 2001, but then failed to answer some detailed questions during their appearance before the Standing Committee on Public Accounts in February of 2001. Given that the Standing Committee on Public Accounts had not had the requisite access or time to properly prepare as a coordinated committee for such a hearing, and the fact that strict access rules apply to the confidential documents that members of SCOPA were allowed to consult but not cite in open committee hearings, these were clearly not the exemplification of robust executive legislative interactions on one of the largest government procurements of the democratic era. Once again, this is a clear policy lesson for the balance that has to be struck in favour of openness and accountability if Parliament is to live up to the expectations of oversight we all believe it to be constitutionally charged with. Lessons learned here relate to classification of documents, something I believe that this Commission has also had difficulties with, openness and transparency, and the fact that with the new PFMA and Treasury regulations, the Money Bills Amendment, the Constitutional Court's ruling in the All-Pay case, and its impact on supply chain management, as well as the robust role of the new Parliamentary Committee on Appropriations, a rerun of the circumstances of the arms deal at the level of executive-legislative interactions has become a lot harder as our democracy has developed deeper systems of accountability.
Right, thank you. That concludes that topic, and now I'd like to invite you to present your evidence in relation to the next topic, which is the cost of the deal export credit guarantee agencies and their role and macroeconomic risks. Please go ahead.
Thank you. In looking at the overall cost of the arms deal, it is important to separate out questions of the process on the finance side, the role of Parliament in the budget process, which has already been discussed, as well as the overall macroeconomic risks and other ancillary costs of the deal. On the question of process, what is significant is the role of the chief negotiator and the affordability team and their respective roles at different stages. According to the press statement released by then President Thabo Mbeki, the responsibilities of the chief negotiator included heading the South African government negotiations team to extract the best possible solution to the financing and industrial benefits accruing from the SDP, preparation and guidance of the teams and key decisions on the route to be followed in pursuing the objectives of obtaining a financing package acceptable to the Cabinet, conclusion of firm contracts relating to the envisaged flows of foreign exchange from the investments and potential exports from South Africa contained in the industrial participation offers received from bidders. These were indeed significant roles, and it is of importance to understand this role vis-à-vis the role of the Ministry of Finance and the Department of Finance, as I've already observed this broad responsibility, as well as placing of the role of the chief negotiator within the Ministry of Defence, had implication for the proper consideration of costs. It is of great importance to note that the affordability team was stripped out of the International Office negotiating team pursuant to a Cabinet Committee decision in March of 1999, and that their study was only fully considered by approximately August 1999, and this would have included the Warburg-Dillon-Reed model, when it was exceptionally close to contract finalization and contract signature, as the preferred bidders had all but been decided, with preferred bidders having been announced in November of 1998. Whilst the Finance Working Group did exist in January of 1999 with the following terms of reference: affordability and increasing the affordability of the deal, assessing the budgetary implications and fiscal impact of the deal, a financial strategy, assessing the economic implications of the deal, undertaking financial negotiations for loans. The affordability team was established in March, and items 72, 1, 2, and 3 of the original terms of reference of the Finance Working Group now effectively became the task of the affordability team. As Roland White is the only official from the Department of Finance who played a role in the IONT, the Finance Working Group, as well as the affordability team, his perspective on the sequencing of the negotiations and the finance and macroeconomic impact issues is crucially important. If the Commission fails to interact with him, I hope that it will be at a bare minimum able to secure the memoranda that he wrote to the Minister of Finance at the time, if it has not already been submitted to the Commission or declassified. A copy of the memorandum from Roland White to the Minister of Finance is not declassified. One could argue that the affordability team's efforts came as a bit of an afterthought in the 1999 period, despite the fact that some officials of the Ministry of Finance were involved in evaluating teams, which were often dominated by DoD technical assessments as well as DTI NIP and DIP assessments that would often leave finance as an afterthought. This can most clearly be seen in some cabinet discussions on costed and non-costed options for the lead-in fighter trainer project. Whilst Mr. Roland White was a member of the IONT, and there was a DG oversight committee comprising the DGs of Finance, Trade and Industry and Defence, the level of coordination between technical specifications and NIPs and DIPs and cost was often insufficient. Again, this is my opinion under oath. The argument that is being offered here is one of sequencing of decisions. Surely it is more sensible to consider the resource envelope that is available and to then prioritize aspects of force design accordingly than it is to select preferred bidders and then to aim to squeeze this force design selection into a budget range that must of necessity and by virtue of other competing priorities be restrictive. I'm not going to rehash paragraph 76, I have dealt with that. I think it would be important for the Commission, as I said, to obtain these memoranda, and I'll also not rehash that. I believe that Roland White also wrote a letter to the chief negotiator, Mr. Jayendra Naidu, citing his concerns about the fact that the submarine contract would be initialed by the outgoing Minister of Defence before the affordability team's report had formally served in Cabinet, which was due to occur in August of 1999. This disagreement between members of the IONT was therefore flagged by a letter from Roland White. This is all drawn from Roland White's testimony during the public phase of the investigations, and it's critical for this Commission to consider it. It is interesting to have noted from Roland White's evidence at the time that the Armaments Acquisition Council formatted the evaluation forms that were given to the Department of Finance officials during the more technical aspects of the process, and that Department of Finance officials had nearly no role in the format of these evaluations or in the weighting of criteria that was used for evaluating purposes. Now, I am aware that 100 marks were awarded in terms of how these evaluations took place, but I do believe it requires a deeper look because there was not an extensive degree of finance involvement in the actual design at this stage. It appears at this stage to have been a mere perfunctory exercise on the part of DOF officials, as the defense role players had effectively selected all criteria and designed the weighting systems. I think that this is an area where the Commission may want to look carefully at the Roland White evidence from the JIT process and Andrew Donaldson's testimony here. I think there are issues here that need to be looked at more carefully. What emerged particularly from his testimony at the JIT public phase of the investigation was his concession that the formulae for the assessment of possible cost escalations were probably not researched sufficiently. It is important to note that the total cost of the arms deal is composed of many elements, including the tender or contract price, statutory and freight costs, project management costs, export credit agency, premia, and escalations. What even the affordability study did not include was the actual operation and maintenance costs over the life cycle of the products, as well as the training and staffing costs to operationally use the equipment. Furthermore, pages 1 and 2 of the executive summary of the affordability study also made it clear that the tranching option that was decided on for the BAE Saab component of the deal meant that we effectively could not cancel the third or second tranche, as we would be paying a premium of 34 to 35% for the aircraft. With respect to the macroeconomic risks, the moderating role assumed for NIPS and DIPS were a factor in the Warburg-Dillon-Reed exercises to assess economic risk, such as the balance of payments and the growth impact. The specific risks that were pointed out by the affordability team were intrinsic risks, non-materializations of NIP and DIP benefits and interest rate movements following the announcement of the packages, and extrinsic risks, unsuccessful defense budget restructuring, adverse rand forex movements, lower underlying economic growth, and cancellation costs. Whilst the affordability team spent a significant amount of time attuning the policymakers to the scale of risk inherent in the strategic defense procurement, they make it clear that it was the decision of the ministers to countenance the level of broader macroeconomic risk they were willing to engage. However, the conclusion of the affordability team is significant, as two specific recommendations require highlighting. The fact that the ministers needed to decide on the expenditure ceiling and leave the negotiation of the specific procurement combination to the lead negotiator and the DoD, subject to final ministerial ratification, and simultaneously with the expenditure ceiling decisions, the Ministers' Committee should decide on the basic question of whether to purchase both Hawk and Gripen at this point, and in particular, whether the tranche option offered by BAE should be accepted. It is of interest to note that according to Roland White, it was the chief negotiator who provided information to Cabinet on the team's hung opinion, but it is possible that the cost impact of the tranching option only properly came to light when the affordability team's report addressed the impact of the base loading of the price of the first tranche as crisply as they did in their executive summary that served before Cabinet in August of 1999. Lastly, it needs to be emphasized that the acquisition process did not include operation and maintenance costs over the life cycle of the equipment, so the realized cost of the SDP and the defense budget over the duration of the equipment delivery schedules would indeed be higher, and this is borne out by the various annual reports of the department. It also did not include the training and personnel costs to operationalize and use the new acquisitions, as these were also additional budget costs that have placed strain on the defense budget, once again, as we can see in various annual reports. On the role of Parliament in the budget process, I've already testified that the architecture has changed significantly. What I would like to highlight, though, is just that the defense procurement approach would have a specifically clear impact on the deficit, as well as the deficit on the current account of the balance of payments. This will indeed hold true for any future defense spending and or large and macroeconomically significant large-scale government procurement. The architecture for executive-legislative interactions on these matters has changed significantly. However, it is up to the members of the House to ensure that this history is not repeated. And I do think it would be a valuable contribution for this Commission to make, to also look at the level to which the democratic institutions and laws have changed and deepened over this period, because there are significant changes and significant differences.
I'm sorry. Do you believe that that point that you are making falls within our terms of reference? We've got 6 terms of reference. The point that you are making, that we must make a recommendation Does that fall within our terms of reference? I just want to hear what your view is because you have made that recommendation. I'm sure you must have looked at our terms of reference. Do you think that point falls within our terms of reference?
Mr. Chairman, I do, with respect, I do believe that it does. Because I believe that the issues that are emerging before you are of such a nature that they effectively cry out for recommendations to be made. And I think that your commission is going to be in a unique position to reflect on the extent of evidence that is being placed before you. On policy issues, not only on the areas that you are focusing on specifically when you highlight 1.5 in the way that you do.
I understand that. On policy issues, does any of our terms of reference require us to make recommendations on policy issues? Let me put it that way. I'm sure you must have looked at our terms of reference. Does any one of them require us to make recommendations on policy issues?
I believe that that is implicit. It's not expressly stated, but I believe it may be implicit.
Particularly by which paragraph? Which one of the 6?
I think it's implicit in all of them.
Okay, thank you. Thank you.
Right, thank you. May I proceed, Chair? We are now in page 30 of the statement. The next topic that you are invited to deal with is item H, NIPS and DIPS, a question of industrial policy.
Ms. Ramaka, shouldn't we perhaps take a 20 minutes break before we come to the next point? I see it's already 22.
Thank you, Chair. That will be proper.
Can we take a 20 minutes break and come back?
Yes, Chair.
My co-commissioner here says 30.
30?
Yeah.
Yes, we would actually welcome that.
Okay,
30
thank you.
minutes.
We'll adjourn for 30 minutes.